Or all of the members of Panel B but one. May we have the roll call?
Dr. Kraus?
Present.
Dr. Bolat?
Present.
Dr. Nanadev?
Here.
Ms. Hines? Here. Ms. Sutton-Wills? Here. We have a quorum.
And I'd like to introduce our administrative law judge, Howard Cohen.
Good morning.
The first item on our agenda is the oral argument on non-adopted proposed decision in the case of Dr. Matthew Vucinic. Dr. Cohen, Mr. Cohen, would you like to introduce our ground rules?
Sure. We are going to, this is before we go on the record. Is the doctor here or his representative?
The doctor's here.
Why don't you step up to the, are you the doctor or the attorney?
Yes, sir. I'm sorry.
Are you the doctor or the attorney?
The doctor.
Okay, good morning. We'll be going on the record in a moment. The board received a request, please be seated, for oral argument. Each side will get 15 minutes. We'll start with respondent, the physician, to make argument based strictly on evidence in the record. The board may, as you make your presentation, ask you to cite what evidence in the record you're referring to. You may not reference evidence that is not already in the record. You'll have 15 minutes each side, and then 5 minutes each side for rebuttal, and then the board will go into closed session. And I'm going to repeat that when we go on the record. I just wanted to let you know what's about to happen. All right? Do you have a card?
Yes.
Thank you very much. All right, let's go on the record. We are here for oral argument regarding the order of non-adoption of proposed decision issued by the Medical Board of California in the matter of the accusation against Matthew Joseph Vucinic, Jr., MD, physician and surgeon's certificate number G43289. Case number 12-2012-221354, bearing OAH number 2015-071315. Today is Thursday, May 5th, 2016. It's 10 a.m. We are sitting with a panel of the board and a quorum of that panel located at Los Angeles Airport Hilton, 5711 West Century Boulevard in Los Angeles. My name is Howard Cohen. I'm an administrative law judge with the Office of Administrative Hearings. I've been assigned to sit with the board to hear oral argument today. Could I have the parties introduce themselves, please?
Deputy Attorney General Lynn Dombrowski on behalf of the complainant.
Thank you.
Matthew J. Vucinic.
Thank you. And I'll ask you to pull the microphone a little closer to you. As you may have noticed, we have a court reporter seated at this table. The court reporter is making the official transcript of this proceeding, and it's very important that everyone be heard so that we can get an accurate transcript. Okay. As I said before we went on the record, each side will have 15 minutes up to 15 minutes. You don't have to use every minute to make your presentation regarding the board's decision to non-adopt the proposed decision in the case below. You can only refer, if you are referring to any evidence in your argument, to evidence that has already been introduced and admitted on the record. This is not an evidentiary hearing. This is an oral argument based on existing evidence. And if the board asks you questions, they may ask you to cite to where in the record the evidence you're referring to appears. So please be prepared to do so. All right, 15 minutes for each side to make a presentation, and then 5 minutes each side for rebuttal. And Doctor, you will go first. You may begin.
All right, thank you for giving me this opportunity to speak before you. I had planned to speak extemporaneously, but realized last night I was so nervous that I wrote notes, so I'm probably going to be reading most of the time so I don't forget anything.
Thank you. And then let me caution you, whenever anyone reads anything, they speed up. So try to slow down so everyone can catch what you're saying. And I'm going to ask you one more time to pull the microphone even closer. Thank you so much. Go ahead.
I am not an alcoholic. I have abused alcohol, as evidenced by my DUI arrests. I apparently was unclear in my December 2015 hearing before the medical board, which consisted of my direct responses to specific questions asked by my attorney and Ms. Dombrowski. It was never my intention to deny that a problem has existed. To me, it's very simple. I know I can't drink before driving, so I stopped doing so immediately after the 2011 arrest. When it was recommended and then required that I stop drinking at any time, I did, without any problem. I have no plan to resume drinking at any point in the future. When I was asked at the hearing, I said I'd like to imagine sharing a toast at my son's 20th wedding anniversary. He's not even married yet, but certainly did not mean to imply that I intended to resume drinking. As noted in the written argument for today's hearing, all the substance abuse experts have agreed that I was safe to continue practicing medicine. The concern, however, had been that I might become impaired in the future. To that end, I have taken significant measures towards my rehabilitation. I have been evaluated and monitored by addiction specialists Dr. Greenberg and Sucher, my employer, California Emergency Physician, my hospital Physician Wellness Committee, and my medical site director. I have been totally abstinent since September 2012 and have had 3 years of uniformly negative testing. I successfully completed the Alta Bates Intensive Outpatient Program at the Merritt Peralta Institute, and prior to that underwent over 6 months of individual psychotherapy. In summary, I have taken my problem seriously and have worked hard at rehabilitation. As far as I can determine, the issue before us today is what further measures and for what duration are appropriate to guarantee my continued rehabilitation and the public safety. I submit that it is reasonable to take into consideration the work I've already done rather than to impose conditions and restrictions as if I was starting at the beginning back in
from a urinalysis, and that 1 year was he was tested by hair samples on a quarterly basis. So that when you say 3 years of testing, it wasn't an extensive, as intense of a testing program as is outlined in the uniform standards that the board has adopted. And Dr. Vucinic, in his presentation today and in the written argument that was presented to the board, also indicated that he, is not an alcoholic, and they argue that he does not have an alcohol abuse disorder. And I just want to remind this panel, although I'm sure you're very well aware, that the board does not need to find that he has an alcohol use disorder in order to discipline him for the 2 convictions that were related to driving while under the influence of alcohol. So the section, Business and Professions Code, Section 2239, Subdivision A, does not require a finding that he is an alcoholic, or also does not require a finding that he is impaired to practice medicine. It only it allows discipline if he has been convicted for more than one misdemeanor related to using alcohol. And so I would remind the panel of that fact. As far as Dr. Vucinic has also asked, both in his written argument to the board on this non-adoption issue and today, has asked to have certain modifications made to the probation terms to accommodate his practice. And it seems reasonable from my perspective to allow him to continue to practice, since even the evaluator for the board, Dr. Sokolov, found him safe to practice medicine and was not impaired to that extent where he had to be prohibited at any point during these proceedings. The one issue about the worksite monitor, I would ask the board to look at that. I do not think that it's reasonable to allow a worksite monitor to be someone who's not physically present for meetings with the respondent. So I would caution the board in considering that request in questioning whether to modify that request. Although Dr. Vucinic today hasn't made the argument, perhaps because it's a legal argument, I just also want to express a certain objection to some of the argument that was presented in the respondent's written argument, and that went to the issue about the statute of limitations questions. And I would just represent to the panel that the issue of the statute of limitations argument was raised at the administrative hearing. Both sides briefed the matter, and Administrative Law Judge Benjamin considered all of that argument and the legal citations in rendering his decision, which was cited in paragraph 5 of the decision, that the statute of limitations did not preclude the board from proceeding on the 2 convictions against him. So all in all, the evidence, as I presented in the written argument on non-adoption, certainly, and as clearly from anyone reading the decision by Administrative Law Judge Benjamin, the proposed decision, the evidence supports the findings that were made there, and he was very thorough in assessing the testimony and the evidentiary, the documentary evidence that was admitted at that hearing. And cause for discipline was established, has been established, and a probation under the board's uniform standards and guidelines is appropriate. Thank you.
Thank you. Doctor, 5 minutes for rebuttal, if you wish.
I have no objection to the addition of the specific requirement of abstinence. Actually, I don't know if this is the proper protocol or the venue for it, but I would really invite questions as far as my requested modifications. I guess the first one being that of the worksite monitoring, which Ms. Dombrowski raised. I believe, well, I would think you have all reviewed the written argument, so I didn't want to repeat any of that. But the situation really is that there is nobody that is physically there at the emergency room every week with whom I would be able to have a face-to-face meeting. I suppose I could. Seton Coastside is a satellite hospital with its own independent emergency room of the larger Seton Medical Center, half an hour north in Daly City, and there are many more ER physicians who work there. I never see them other than once or twice a year at most at continuing medical education meetings. But I do often confer with them on the phone when I'm transferring patients to that place, but it still is, they're not physically present. If the board thinks that appropriate, I'm sure I could work out a situation where I would go up there to meet with somebody, but once again, it would most likely be not the same person every month because of the way schedules are. Regarding the drug testing that I've had, after the first 2 years of the random urine testing, Dr. Sucher, who was the substance abuse monitor, had decided that there was no reason for continued testing, and I requested that this be continued to document my continued abstinence, and he agreed to then do the quarterly hair testing with the rationale that should the test is sensitive enough to show if I had indulged on a binge, it would show up, and he said that the only thing on the basis of my record, if there were to be any kind of relapse, it would be in a binge term, and so for that reason, he thought that testing was more than adequate. I certainly would have, had asked for continued of the regular, but that's all I have to say.
Thank you, Doctor. Ms. Dombrowski?
I have nothing further to add.
All right, then I'll ask any members of the panel whether you have any questions for the respondent. Go ahead. And say your name first, please.
Howard Kraus. I would like to inquire of the Deputy Attorney General if she has any comments regarding Dr. Vuksinich's request that any testing be done at the end of a shift rather than on the day of the request, which would interfere with his work schedule.
Dr. Kraus, I don't have any particular comment to that. I think you, as a physician, probably has more knowledge than I do about the reasonableness of that request, but I can see that would be acceptable to, I think, I don't have any objections or any evidence that would say that it's not something that's reasonable.
Thank you.
Yes, state your name, and do you have a question for the Deputy
Doctor,
Attorney
yes.
General? For the
No,
doctor?
Yes.
Okay, then, Doctor, please raise your right hand. Do you swear or affirm that your testimony in this proceeding will be the truth, the whole truth, and nothing but the truth, and has been?
Yes, I do.
Thank you very much. You can go ahead, state your name.
Dev Gandadev, board member.
Thank you.
Thank you, Judge. Dr. Vucinich, what really bothered me here, you're an ER doc.
Yes,
I'm
sir.
a trauma surgeon. You see more injuries from drunk driving than any other a doctor can see. So having 2 arrests was worrisome. Then you coming up and basically saying that, well, I'm not alcoholic, that was a second worrisome thing. If you have twice, there is a reason. So abstain, I'm glad I heard that from you, that you are okay with abstain from alcohol or substances. That is extremely important, and that's why I'm glad you came up with. I do understand your worksite monitoring issues, but tell me a little about why do you think that you don't have a really serious alcohol problem when you got stopped twice?
I think by definition, the fact that I was arrested twice means that there was a serious problem. The first instance was on my 50th birthday when I was pulled over for a burnt-out headlight, and I had no idea whatsoever that I had been consuming to the point where I would have a BA of .06. And as a result of the surprise of that, it didn't at that point sink in that, oh, this could be, something deeper. I looked at it as an extremely unusual kind of occurrence that since I wasn't a regular drinker or even a binge drinker when I did drink, that a wet reckless was something that I should consider my alcohol consumption, but it really didn't ring any bell. And then on the second arrest, it was a situation of I would not have got behind the wheel if I had any suspicion that things were amiss. And as a, in fact, I'm a mandolin player and had just finished a concert in downtown San Francisco where my elderly cousins came to visit. And after the performance, we went to a local bar, and I consumed 2 martinis, which is, I'm not a bar drinker. I hadn't seen my cousins in almost a year. And again, as I walked to my car to go to the second performance, I actually did not feel impaired and didn't even question to myself that I could have been impaired. And when I got close to my destination, as a matter of fact, and realized that I had missed a turn, I pulled into a 7-Eleven where there was a police car in the parking lot to ask for directions. And seeing the police car didn't give me any hesitation because I wasn't aware that I was intoxicated. So the result of that arrest was loud and clear. Wow, you can't tell if you're intoxicated. So that's why I went through all these steps. And to me, since alcohol wasn't something that was necessary, it was easy for me to just say, okay, I can't do it, I stop. And that's why I don't think that it's a continued or an ongoing issue. In the same kind of way, I suppose that if I was told that I had high blood pressure and had to abstain from salt or be on a medication, that would be okay. That's the only logical thing to do, and I'll do it. And having said that, it really was no effort at all to cease completely, and I don't see that after almost 4 years of abstinence, it would appear to come and be a problem again. Did that answer your question?
Somewhat. Thank you.
Any further questions from any members of the panel? You do? Okay. State your name and ask your question.
Brenda Sutton Wells. Doctor, you said that it was not possible to have supervisors per se present, but that you don't go unsupervised. What did you mean by that? Who actually is present?
The only people present are one ER nurse and then the physician who I have relieved when I come on to work, and then the next physician who relieves me when my shift is over. However, over the course of the shift, there are frequent phone calls to other physicians at receiving hospitals. We don't have any inpatient facilities, so anything requiring hospitalization needs to be transferred. And inherent in a transfer, you need to discuss the case with the receiving physician to get acceptance, sometimes several consultants as well. So it's supervision. That's what I meant by supervision. I have ample contact with a number of physicians during every shift, but none of them are there. This is all over the phone.
Any further questions from the panel? No? All right. Well, then that will conclude the hearing on oral argument on this matter. With that, the record is closed, the matter is submitted, and we'll go off the record. Thank you very much.